The last topic we are going to talk about in this week is about the policies attempting to stimulate universities' patenting and licensing activities. Here, the key issues that are being talked about or being discussed is that when you are talking about patenting, this is in fact an outcome of the publicly funded academic research. For instance, in a country like India, where most of the institutions are being developed through the public funds, then how far this kind of a patenting would be appropriate? Because the question is, should the publicly funded research be allowed to be patented? Because if you remember our discussion on patents and IPRs related issues, we have talked about how it will create a deadweight loss to the society, because a certain amount of monopoly power would be created with respect to the patent owner, and as a result there would be a static loss that will occur in the economy. Now, if the funds which has been used to actually produce or to create that kind of a research outcome is in fact coming from public, then what you will find is that the public is now getting affected twice. On the one hand, they are the major sources through which the amount is given. That means they are funding the research. And secondly, when an amount which is being supported through the taxation that is being collected from public is now supporting the research activity and leading to a patent, it might lead to a higher margins of the price and leading to a certain amount of presence of monopoly power in the country. So looking at this very a condition, a kind of a dilemma, you may say, the question is that whether publicly funded research should be allowed to be patented or whether it should be completely available for access and commercialization of everybody. The next point, a related point, is should academic institutions then generate resources using the public fund? Because initially, if you look at the patents that are generated are because of the funds which has come from the public. And now if they create patents, commercialize them, and then they generate resources, should those not be now put back into the government? Should not they be put back into the government treasury? Apart from that, certain important related issues are with respect to licensing. Say for example, a patent has been granted. Now that has to be a license to the another industrial partner. What type of licenses, exclusive versus non-exclusive, should be given, and that will fulfill the overall societal objective also with which these public funded research organizations has initially come into picture. So those are some of the tricky or key issues, in fact, that need to be addressed, that need to be debated upon while discussing about the policies that will support the patenting by the public funded academic research institutions. So moving forward, the most important discussion in this area actually come forward when in America the Bayh-Dole Act, which was earlier known as the Patent and Trademark Law Amendment Act, was enacted. It was a federal law which was enacted in the year 1980, and the key feature of this particular act was that it enabled universities, non-profit research institutions, and small businesses to own, patent, and commercialization inventions which were developed under federally funded research programs within their organization. This act was in fact supported by two senators, Birch Bayh of Indiana and Bob Dole of Kansas, and hence the name Bayh-Dole Act as such. There were various patents which were already filed by the American universities even before the Bayh-Dole Act was being filed. So, but what happened? What are the major changes? The change is indeed was that it facilitated, it replaced a web of institutional patent agreements that were earlier negotiated between the individual universities and federal agency with a uniform policy. And as the Act make provisions which were expressed congressional support for the negotiation of exclusive license between the universities and the industrial firm for the result of the federally funded research now. So it created this kind of a space for the universities where first of all a facilitation has happened. That means that earlier there might be a different set of agreement that need to be talked about is now being replaced by a uniform policy. Secondly, they were also being allowed to give exclusive license if it comes to that in order to universities if that kind of an exclusive license is going to support the technology transfers as such. So then this entire Bayh-Dole Act and the impact it had on the American universities patenting, licensing, etc. initiated the discussion in the other countries, including European and Asian countries, about the need to have this kind of an act. However, before we go into that, let us first look at the key provisions of this act, and also what does empirical effect or the empirical results show us with respect to the effect or the implications of this particular act. So what were the key provisions? If you look at it, then what you find is now the universities are entitled to retain the ownership of any invention which might be created as a result of the federal funding, unless the funding agencies inform the universities otherwise under the exceptional circumstances. University also must patent all inventions it elects to own, and if it elects to own, and also try to commercialize them. The university must provide the US government with a non-transferable, irrevocable, paid up, non-exclusive license to use the invention in case of a need. Moreover, in granting a license to use the invention, the university also generally must give a priority to small businesses while maintaining a fair market value of the invention. Moreover, the excess revenue is now which is being generated, it must support the research and education. Apart from that, university must share a portion of the royalties with the inventors. So with these key provisions that are being introduced in the Act, now let us see what were the motivations behind enactment of the act, and also how it kind of renewed the innovation activities in the public funded university. So in 1920, a very few universities were patenting in America, and only a few institutions developed a formal patent policies. Several of the most lucrative patents in post Bayh-Dole, in fact, has been shown by Mowry. They were actually filed before the Bayh-Dole Act as such. So a bit of a critical assessment of the impact of the Bayh-Dole as such. There also existed a variation that we have already talked about in the rules and the procedures for doing so across the numerous agencies. Apart from that, Sampath's research has also shown that universities previously avoided licensing activity because they were concerned to compromise their mission to widely diffuse science and technology. Any kind of an exclusive license would mean that a particular private industry has now an access to this innovation which has come through the university or a public fund research. So as late as 1978, what we find is the federal government has licensed less than 5% of the as many as 30,000 patents which were being owned. That means that though the patenting activity was going on, there was limitation in terms of the licensing of it. Very few US universities were engaged in the technology transfer, and in fact had the patent offices, technology transfer officers. The presence of this kind of an infrastructure is very important to support the technology transfer activities of the universities. So whether the passage of this act in fact renewed the American innovation policy, clearly there are certain positive points. For instance, it created clarity and uniformity in processes for ownership of IP from the public funded research. It also codifies the process through which the institution now must disclose and report the public funded IP. It also created a certain standard set of rules across the funders, spurred more universities to work closely with industry, and created a powerful vehicle for leveraging US investment in basic research. It also decentralized technology management to universities and businesses that invented the product with the government support. So what we find in terms of empirical evidence is that the university's share of patenting increased from less than 0.3% in 1963 to nearly 4% in 1999. American universities experienced a tenfold increase in their patents, which created more than 2,200 companies to exploit their technology. Moreover, academic technology transfer was also being now supported, particularly the launch of over 1,200 startups since 1995. According to a report prepared by OUTM and the Biotechnology Industrial Organization from 1996 to 2015, academic patents and their subsequent licensing to industry in fact bolstered the American GDP by $591 billion, contributed 1.3 trillion in gross US industrial output, and supported more than 42 lakh persons years of employment. So that means there was a thriving technology transfer mechanism which provided the number of the invention disclosures in fact increased to more than 25,000. led to the discoveries led to 7,000 US patent being issued. It also, the survey shows that it identified 1,000 new startups formed on the basis of the technology transfer. The public-private partnership began to furnish in the field of biotechnology. What was being found that more than 200 drugs and vaccine has been developed through PPP since the Bayh-Dole entered into force in 1980s. Hochman in 2012 has argued that it increase in the university interconnectedness with the industry under the IPR regime produce important local economic benefits. Long-run employment, payroll per worker, and average establishment size grew differentially more after the 80s in industries more closely related to the innovation produced by the local university or hospitals. However, this research is also not without its critique. For instance, a study has found out that the ratio of the research university patent to academic research spending remained rather constant through 1963 to 93, and it suggested no significant increase in the university propensity after the passage of the Act. So, one way to look at it is the total number of the patents being filed. On the other hand, you also have to understand that the total number is in a way related to the research and development spending. That means the R&D investment that are being made. Accordingly, when we talk about the patent propensity, that means ratio of research university patent to academic research spending, that rather remain constant. AUTM licensing survey in 2007 also highlights that in 2006 the licensing revenue, whatever being generated, it was rather a minuscule share of only a little more than 3% of total academic R&D fund. Nelson, who is the Director of Technology Licensing Office at NIT, has observed the direct economic impact of technology licensing has been relatively small. Most university licensing officers barely break even. The three top revenue earners in the post-Bayh-Dole Act, Columbia, California, and Stanford, the bulk are rather driven by the small number of inventions. I mean, in fact, if you look at these results, you will once again understand when we talk about the stylized fact, there we clearly pointed out that some of these inventions or some of the inventions which will now be commercialized would rather be limited out of the many as such. So here also what we find that though there might be an increase in the technology licensing activities, the bulk of the revenue was rather being driven by the few inventions as such. Moreover, patenting and licensing of inventions are a relatively unimportant channel in most industries. That has been pointed by Cohen et al. In the earlier study, and we have talked about it also. Thus, the studies remained inconclusive on whether technology transfer outcome has rather increased, though they have increased the absolute number of the patents as such. So the studies highlight that the patenting and licensing of inventions in fact are a relatively unimportant channel in most industries. That also we have studied earlier. So that means even if the licensing agreement with respect to the universities are limited to few inventions, that is something which is a pattern across the different fields as such. Studies remain inconclusive on whether technology transfer outcomes has rather improved, but clearly there is an awareness issue, and it is difficult to disentangle whether Bayh-Dole enhanced in awareness of the patent issued among the universities, or whether this increased awareness was itself a motivation for the passage of the Bayh-Dole. So the development of the establishment of the causality is rather being questioned. But what you find is that a focus on IP, it may be leading universities to be so aggressive in their pursuit and defense of patent that in fact it may actually hinder the other activities of the research. That means there could be an issue with respect to the direction of the research. More and more research fund might be invested or might be given to the research group which may be in conducting research on the so-called hot topics which are now producing more and more patent. Basic research, if there is a possibility, might be actually ignored as such. This is one of the point of the criticism of patent system which we have done when we talk about the intellectual property rights. Moving forward, there are definitely international experiences. That means following America, many European countries, they also enacted laws in the last 17 years. The idea is once again to substantially alter the rights to the university-based innovations. In Germany, Austria, Denmark, Finland, Norway, new laws actually ended the professor privilege. Norway ended the professor privilege in 2003, by which the university researchers has initially enjoyed full right to the new business ventures and IP that they created. The new policy in fact transferred two-thirds of these rights to the universities themselves, creating a policy regime like that was typically prevailing in America. The Chinese version of the act was passed in 1999. In case of India, what we have find that a bill on a similar line was proposed in 2008. It was called the Protection and Utilization of Public Funded Intellectual Property Bill. It proposed the mandatory disclosure of all inventions by universities and public fund research institutions within the stipulated time period to appropriate authority for patenting. The act as The bill, in fact, suggested that the major motivation was to provide incentive for creativity and innovation, to ensure access to such innovation by all stakeholders for the public good, to encourage innovations in small and medium enterprises, to facilitate and commercialization of intellectual property which is created out of public funded research and development, to promote the culture of the innovation in the Indian universities, to promote collaboration between government, private enterprises and non-government organizations, to increase the responsibility of the universities, academic and research institutions, to encourage students, faculty and scientists to innovate and to raise royalty income. Apart from that, one of the another objective was rather to enhance the awareness about intellectual property issues, especially in universities, academic and research institutions as such. So, the bill was rather being proposed, it was being discussed. However, in 2014, the bill was withdrawn. So, if you look at in fact, at that time also, there was a lot of discussion in terms of whether the act will actually achieve what it intends to, whether the Indian universities, academic institutions are ready to deal with an act like that, and as an outcome of that, after the committee meeting, we find that the bill was withdrawn in 2014. But does that mean that Indian institutions are not engaged in patenting? In fact, that is not the case. Post-TRIPS agreement in 2005, that is, once we meet all the requirements of the TRIPS agreement, in fact before that also there has been a focus on patenting by academic institutions. A recent data from Indian Patent Office shows that among the top 10 institutions of India filing patents between 2019 and 2021 in fact include institutions like IITs and Chandigarh University. There you find that the collective numbers is rather 1901 in 2021 as such. Apart from that, Chandigarh University has also been applying for the patents to the more than 1500 such inventions. And apart from that, there are other emerging private institutions like Shulani University of Biotechnology, Shobit Institute of Biotechnology and Management, Galgotia University and SRM universities. So what you find in terms of an ISE, earlier we talked about the cluster development in India in terms of the Silicon Valley of India, we have seen Indian Institute of Sciences has played an important role there by providing the skilled labor. Here we also find that ISEs, researchers and scientists are rather filing more than 3,000 patent applications from January 2001 to December 2022. In fact, ISE has been granted a total of 145 patents in the year 2022. What does it mean? It means 2 patents every 5 days. So in a working week, ISE gets 2 patents. And in 2022, this itself, 585 applications were filed by ISEs itself, which was up from 512 in the previous year. So clearly, patenting activity has become a very important and significant part of most of the academic institutions in the country, which includes IITs, ISCs as well. There what you find, if you look at this table, which is once again coming from Mani's article, which is about India's quest for technological self-reliances and analysis of record with respect to patents in the post-TRIP phase. So here what we find is that the top applicants in the IT sector, and with respect to the data is coming from the Indian Patent Office. There they find, Professor Mani has pointed out that IITs has in fact a collective of 212 patents through 2008-9 to 17-18. Apart from that, other academic institutions which you find including like SRM universities also. Then In our research group on innovation studies at IIT Indore, also we have conducted a research on patenting by academic institutions. The focus of that research was mainly IITs. Some of the major conclusions which we get from that research are being discussed now. Most important driving factors, if we talk about innovation, includes this funding, what are the locational factors and the institutional policies. Secondly, the overall time which is being spent by the researcher on the activities, their age, experiences, research attitude and internal motivation of the research staff, faculty members are very important. What we find is the collaborative research and academic patenting in fact provide incentive in the form of joint projects, collaborative publications and consulting opportunities. It encourages research personnel and students to undertake risk and venture into the entrepreneurial activities. We find that a very good support from the Indian government to academic institutions at that point of a time when we conducted the research was called as planned fund. It does take a certain time period before it realizes into an outcome like a patent or publication. So there is a rather a lag involved in terms of the grant being received and the final outcome, which is understandable because once you receive the grant, you have to spend on it the research activity. Maybe you have to procure certain instruments and the research happens, and over a period of a time only it can then translate into the patents or the publication. Then the proximity or the location of the scientific department also is playing a very important role. There you find that the department, if they are located in an area in a related industrial unit, it will lead to higher publication output per faculty. Basically, the focus here is the information flow that happen from the industry to academic research. Apart from that, our research highlighted the role of the institutional factors in determining the patenting activity, joint management of IP activity by all the stakeholder, the immediate recognition that is being given in the institution to the IP activities of the researcher plays a very important role. There is a need to link the reward system with the patenting probability and intensity, and it will bear positive results for the institutions. However, it has also been pointed out that this kind of a patenting criteria for the advancement of career should not be applied across all the disciplines. What we have identified that different disciplines has patent intensity which is different. As a result, some are more inclined towards patenting as compared to another. As a result, you cannot have a uniform policy of patent being filed across the disciplines. Say for example, we may not find many patents being filed in the mathematics department, whereas in a biomedical or a biotechnology department there may be much more. As a result, one has to understand the requirement, nature of the disciplinary output, individual motivation while designing this kind of a criteria. One important factor that does come from that research is that active participation of the institution in having a very clear-cut IP policy, having a clear-cut technology transfer policy facilitate these kind of activities of the faculty members.